hi everyone. We are so glad that you were able to join us today for this special webinar on fine-tuning your visa doctor recruitment and hiring efforts. My name is Amber, and I'm a member of the marketing team at Wright Constable and Skeen. Before we get things rolling, just some friendly Zoom reminders that I'm sure you're all already familiar with. First, please remain muted during the presentation so that we can avoid any unwanted background noise. Jan has also asked if you're willing to please be on video so that we can see the lovely humans behind the screens. The presentation is being recorded, so it will be available on YouTube and podcast streaming services next week. In addition to the WCS website, you'll all receive an email with those links when they're available. And lastly, if you have any questions, please go ahead and enter them in the chat box. We'll address those at the end of the session during a Q&A. I have the wonderful opportunity to work with Jan and her team as they tackle J1 waiver physician issues. So let me take a moment to introduce our speaker. Jan Peterson has been a tireless advocate for J1 physicians for over 30 years. She co-founded the International Medical Graduate Task Force in 1990 and was awarded their Lifetime Achievement Award for her incredible work on behalf of J1 physicians. She is also a recipient of the most prestigious National Award for Excellence in the Advancement of Immigration Law, the Edith Lowenstein Award. Jan is active in bringing immigration issues to the White House, Congress, and the executive branch, resulting in many positive changes, as well as effectively representing thousands of physicians and their employers in their waiver cases. Jan is currently in recovery mode in preparation for her continued passionate advocacy for her clients, and thus won't be on video today, but you will see her lovely photograph accompanied with her insightful voice. So, Jan, if you're ready, I will now go ahead and pass to you.
Thank you so much for that lovely and undeserved introduction, Amber. I assure you all, my picture looks better than I do right now, but be that as it may, I am welcoming you to what I hope will be a wonderful and helpful seminar to all of you extraordinary recruiters, in-house and external. So we're in the middle of football season, so we're going to talk about most valuable players, and those are the doctors that you want to recruit to work for your employer. So I want to welcome all of you in the audience today and thank you for joining us through this journey together, which I hope will be painless. Traveling down the J1 waiver road can seem daunting, complex, and nonsensical at times, and it's all of that. So hopefully we are going to provide you with the tools for smooth sailing with a visa doctor and a glitch-free journey. I would say that I am the leader of the immigration group at Wright Constable and Skeen, and we have the benefit of the lovely Amber to help us put this program together. And I want to thank Amber, Corey, and Ola and Natalie as part of our team here for putting this together. But also let you know that we're available to represent you and your J1 physicians and have represented thousands of physicians, recruiters, and hospitals and employers of all types. I want to let everybody know that behind the scenes, we're working on laws to benefit you and your physician in terms of reducing the barriers to recruitment and retention and to get the process, more certainty into the process. I want to acknowledge a very special guest we have here today with us, and hopefully she won't ask me questions that are too difficult, and that is Ellie Fitzpatrick. She is the one person most responsible for having all the J1 doctors in the United States. She worked for ECFMG, the Educational Commission on Foreign Medical Graduates, which is the organization which credentials physicians in order for them to start training here. So welcome, Ellie.
Thank you, Jan, and I want to clarify that I am no longer with ECFMG.
Okay.
Jan and I go way back.
But she is
years ago.
All right. But Without further ado, we're going to go for about 50 minutes and allow 10 minutes for questions. We can go a few minutes over if you wish. So tips for building your winning team of visa doctors. We'll put our usual disclaimer that nothing you hear today is legal advice, and participation in the webinar does not create an attorney-client relationship. And the general opinions expressed are the opinions, my opinions, and may not reflect the opinion of everyone. Okay, for those of you unfamiliar with this, or maybe somewhat familiar, I'm going to go through what we call the visa doctor alphabet soup. So the physician immigration world, as you know, abounds with acronyms. Here are just a few. Okay, your J1 physician is called a J1 physician because they enter the United States on a J1 visa with J1 status. With that admission comes the obligation to return to their home country for 2 years before being able to work in most cases. And then comes the prize, unless a waiver is granted. There are many types of waivers, and we will get into those. Now, the other flavor of physician, a visa doctor, is an H1B physician. Those have become very rare. There are physicians who are never on a J1, don't need a waiver, and undertake their training in H1B status. The advantage of those doctors over J1 physicians is they don't have a home residence requirement. They can work almost anywhere. There's a limit of 6 years in H1B status, and you must usually have an H1B cap exempt employer. Do not be intimidated by the 6-year limit because it can be waived. Okay, the next thing you all probably have heard of are state 30 J1 physician waivers. Okay, they're called Conrad State 30s, but they are the most well-known and popular type of waiver to date. And remember, every state in the United States can grant up to 30 waivers per year. And states include, and this is an important one, the District of Columbia, which never uses close to 30 waivers, so we welcome you all here in DC, Puerto Rico, Guam, Virgin Islands, and Northern Mariana Islands. So all of those get to issue 30 per year, and that's regardless of the size. And the important thing for you to footnote is that each state at its discretion may use 10 of its 30 waivers per year for what we call flex spots. A flex spot is where you recruit a physician who will not physically be located in a medically underserved area, but will serve some patients who reside in those areas. And each state has the discretion to compile their own rules and protocols for allocating both their 30 waivers, and among the 30, the 10. Are they going to use their flex 10 slots for underserved areas? Their willingness to do so depends upon the demand in that state for slots for underserved areas. Okay, so the flex slots we just went over, but just remember that when a lot of your employers will say, I can't do it, don't give me any J1s, we're not an underserved area. They all assume those things, and it's worth you looking into to find out whether it can be done in a flex area. And please note, many universities can get flex slots because an underserved area at the end of the day is the definition of how many the ratio of primary care physicians to population, roughly one primary care physician for every 3,000 population. So that's a big recruiting plus. If you're in a state that has lots of flex 10s available, then you're able to recruit doctors you otherwise would not to non-underserved areas. And I can go into it. If you ask me about various states, I'll go through the states. All right, so that's your recruitment. I'm going to tell you that plus. And the next one is some more alphabets that are kind of annoying. These are agencies. The first three are agencies. They are federal agencies. So we have two baskets of waivers. The state 30 given out by each state Department of Health, limited in number, on an annual basis. And then we have the federal waiver programs. And the federal waiver programs, important to remember, especially this time of year when people are panicking, is they may give out an unlimited number of waivers and are open year-round. The first and the oldest waiver program, other than the Veterans Administration, is the Appalachian Regional Commission. And this is a geographically defined area which roughly covers parts or all of states that run along the Appalachian Trail. And that would be from the southern states of New York down through Georgia. A new feature of the ARC waivers is that they will sponsor all medical specialties. Until I think it was 3 years ago, primary care only. Now it's open to everybody. You just have to be in the right area. I would also warn that you want to talk to your physician immigration attorney to find out whether that works for your situation. They are paperwork heavy and have a longer processing time. The second one is the Delta Regional Authority, again, geographic, roughly running along the Mississippi River, starting at the southern Illinois and going down to the Mississippi. They are very user-friendly. They do have a fee of $3,000. And they are generally very quick. I would say that you may have heard a lot of complaints during COVID that you couldn't get phones answered and emails answered, and they were just swamped. Now, today's winner in the program is the HHS. We're extremely proud of HHS. Last year, I think it was about May of 2020, they opened up the types of employers for whom they would sponsor waivers. So before that, it was very narrow and virtually usable only by federally qualified community health centers. Now they will accept waiver applications for all healthcare facilities with a HPSA shortage score of 7 or greater. However, they are still limited to primary care physicians. And just for the definition of primary care, that would be family medicine, internal medicine, pediatrics, OBGYN, and psychiatry. Now, should you have somebody who did do one of those residencies, but perhaps did a fellowship in geriatrics or something of that nature, the HHS will be flexible as long as the physician agrees to start work within 365 days of finishing their residency program. So the most common one we see in this situation are geriatricians. And so we are successful in making sure they get to work within a year. And you don't want to fudge on that. You want to make sure that the doctor knows in advance and they have arranged with their program to start a week early or something in June of the year that they're going to start work. And the even bigger boon is that HHS magnanimously included hospitalists as primary care. And that resulted in them having in the last year, I think something like 258 HHS waivers. So they are wide open. So your caveat there is be sure to look up whether or not your place where the doctor's physically going to work has a HPSA shortage score, MUA area. So just to elucidate there, for those of you not familiar, we have two types of shortage areas: HPSA, health profession shortage area, and MUA UP, which is medically underserved area. None of the HHS will not do MUAs. So that is a big boon to all of you in your recruiting, because so many of the waivers nationwide are used by hospitalists that very, very many of them can now be diverted to HHS waivers, which again are unlimited in number and open year round. And believe me, this is not a paid political advertisement for HHS, but they really stepped up to the plate during COVID and have really done an amazing job. If you can get an HHS waiver for your doctor, don't think of anything else because they do them very quickly, as quick as a day to a week. Basically, they are adjudicating cases 1 day a week, and whatever's complete on that day gets approved. So remember that program. So those of you who are with hospitalist companies have a real boom there. So it's also the fact that they're certain. So State 30, by nature, it has a built-in uncertainty. How many other people are going to apply? How are they going to be ranked? Well, everybody who meets the basic qualifications of HHS wins. So that's a real touchdown. Thank you, HHS. Now, those are your interested government agency waivers, both federal and state. And you may have encountered other types of waivers where the physician does their own waiver. It's self-sponsored, basically. A hardship waiver and persecution waiver. They have an extremely high approval rate, close to 100%.
Very I don't want to say upscale because I don't know what the word is, but like just kind of janky.
Like too fancy?
Like not fancy enough.
Oh.
Like back in the 70s.
Oh, okay.
Their equipment and everything.
Okay, so hardship waivers are great if you can get them. The advantage to both hardship and persecution waivers is the physician can make their own application at any time during their residency training, even their first year. And if it gets approved, great. You have some other issues, but you don't have to worry about a waiver. So hardship waivers are good. It's very country specific based on geopolitical conditions. For example, if you have a physician from Syria and they have an anchor relative as described there, a U.S. citizen or permanent resident, spouse or child, then they can go into that basket. But both of those waivers, right now you have to count on about a year. So there may be a timing issue on that. Next slide. Okay, so you all know what an H-1B is now, temporary visas for professionals granted 3 years at a time for a total of 6 years, which can be waived. The next one, which is a huge recruiting plus, I think everybody knows about this these days. 2 years ago, the doctors didn't know, the employers didn't know. It's called the Canadian Citizen Exception. And I'm very honored to have negotiated that exception way back when. So if your doctor can't get a waiver, it's not feasible, not available, timing's up, whatever it is, and they're a Canadian citizen, not Canadian born, but a citizen holding a passport, they can obtain an H-1B status without a J-1 waiver. So that's a real advantage to both you and to the physicians, that if you're out of waivers, or it would be basically if you're out of waivers, then they can start work in H-1B status. So that's another pool that you may not have known exists for your recruitment. Next. Okay, so I just defined HIPSA and MUA. All these slides will be available to you. Let's have the next slide. All right, so something about the current environment. All right, the demand for J-1 waivers has increased dramatically, but the good news is the supply has exploded. So you want to recruit J-1 physicians carefully, as trade-ins and transfers are expensive and uncertain. But in onward, usually we come into this when the job doesn't work out for whatever reason, and the physician needs to depart from the job during their 3-year waiver commitment. So if you're on the receiving end, you're recruiting somebody who's leaving their job. I've gotten just this week 4 calls from recruiters saying, can I recruit this and can you guarantee that they'll be able to transfer? Well, you can't guarantee it, but we have very little, I can't remember a time when a transfer was denied. It has to be done carefully. So a transfer is allowed from one employer to another during the 3-year waiver commitment if you can prove extenuating circumstances which are not well defined. So we just start out analyzing a situation by saying, is there an unforeseen, unforeseeable, and unanticipated circumstances that cause the employment relationship to dissolve? And we spend a lot of our time negotiating those. So everybody wants to make sure, as to the extent possible, that there is a good fit. Okay, so over 80% of entering foreign medical graduates now enter in J1 status, thus need to obtain a waiver to remain after training. The number could even be higher now. Ellie, if you want to chime in, if my number is higher than 80%. It used to be about 50-50, 50 entered in J1 status and 50 in H1. Now it probably is even less than 80%. But among the physicians, they believe that, coming in on a J1 carries a 2-year albatross around their neck, or 3 if they're going to do a waiver. And it's like having a Volkswagen, and having a H1B is like having a Rolls Royce. However, at the end of the day, they usually end up in much the same place. Now, anecdotal evidence indicates that J1 physicians stay longer than U.S. physicians in the underserved communities where they are recruited to work. So we want to do everything possible to choose the right doctor who's going to build a life and stay in a community. As I always tell the doctors who say, well, I'm going to worry about my child getting a good education if I go to a small community somewhere. And then I tell them that if they're in a small community in West Virginia, the chance that their child will get into Harvard is far greater than if they're in Virginia or New York or somewhere like that. And I also point out a number of our U.S. presidents that came from grossly medically underserved areas and rural areas. So that said, it's worthwhile taking the time to see what the needs of your J1 physician are, and make sure that they will stay. Some of the things that I found over the years that can work are, rolling out the red carpet when they come to town, because as a matter of fact, through the years, they sort of get the last choice of residency positions. They feel perhaps that they're discriminated against in the process. So everything you can do to welcome our best employers, just roll out the red carpet. Somebody picks a doctor up at the airport, make sure they meet the hospital administration, the community leaders such as the mayor. I mean, it sounds like maybe a small thing to us, but mayors love to meet new doctors coming, say, or politicians. And the mayor wants bragging rights. Hey, we got this new smart doctor out of New York, and he's in our community, and he's chosen us. Hook them up with a real estate agent, try to get good mortgage rates, because I don't know if you know this, but generally if you're on an H1B, you pay a mortgage of something like 20% down and very high rates. For some reason, they don't believe you're going to stay, but in reality, they don't. So drafting MVP positions, we're right in the middle of the high season for waivers right now. People are panicking. A number of states have programs that close October 31st. A number of states have used up all their waivers, not many, but there's still many left. Okay, so the way that works. So federal, always a backup and probably a first choice. So the other thing in drafting your MVP physicians is look at the spouses. If they have an unhappy spouse who can't work in your town, in your area, they're not likely going to stay. Many times you will find a bonus in that there's a spouse of an H1B and H4 status, and they can obtain work permission in H4 status if the conditions are met. So remember, many of the spouses are also H4 physicians. And what I've learned from the doctors and talking to many, many doctors is that they're reticent to bring up at their visa interview their spouse and their spouse's immigration needs or situations. There's some belief that that will spoil the deal or not, but we always do an immigration checkup for our employer clients, and we ask about that situation because we want them to stay. If they're going to be commuting 6 states away from the spouse, then there's a problem, right, with retention. Okay, so Canadian citizens, we got that. That's another recruiting bonus. And then, of course, physicians who have completed training in H1B status do not need waivers. That's a more complicated conversation about how to handle this. There are some restrictions, even though they can get H1B status. Okay, next slide. Okay, the cost. All of your employers want to know how much it's going to cost and how long it's going to take. So how much it's going to cost is right now, your biggest fee are the government filing fees. And embarrassing for us poor lawyers to say the government filing fees are often higher than the legal fees. So J1 government filing fees, who pays? The best practice is for the employer to pay. In some areas, it might be legally required. In several states, there's a decision covering those states. All right, sample fees, Ohio, Texas, DRA. The ARC recently eliminated its $3,000 fees. So there's that fee to consider. It's a state-by-state thing. It's generally on the website. You just Google whatever state you're interested in, like Nebraska, Conrad State 30 program, they will tell you. So H1Bs our rules are very clear, is employers are required to pay the legal fees and the US government filing fees. Okay, and filing fees, this can be an initial outlay of up to $4,960 at the moment, just for the filing fees. Now that amount includes the optional $2,500 premium processing fee. What you get for your extra $2,500 is the guarantee of an adjudication by USCIS of your H1B petition, which of course is filed after the J1 waiver is approved. And you get certainty, but basically you'll get an approval or the dreaded request for evidence, which is basically eats up resources of employers and lawyers and answering them, or a denial, which is very uncommon. Legal fees, an additional expense. Use your secret weapon. Partner with an expert hands-on physician immigration attorney early in the process. What we do for our clients is do immigration checkups to see what issues they are, what their concerns are, what their spouse's immigration needs are, and things of that nature. So if you, you definitely want to be with a hands-on immigration attorney to answer your questions and the recruiting fee. Next. Okay, so that's the cost. The timelines, of course, have gone a little haywire with COVID. The government's still putting out COVID as a reason for delays. But there are delays, whatever the reason, from 2 years ago. So the processing times are, for the interested government agency waivers, step 1 is anywhere from 1 day to 6 months. I think the most we had this year was 6 months. Very painful, very time consuming, and causing the physicians great anxiety as well as the employers about when they could start scheduling patients and seeing patients. So that needs to be factored in. Once the state or federal agency approves the waiver, they recommend it to the Department of State in Washington for their recommendation, and their processing times have slowed way down from, they're now 4 to 14 weeks, which is the highest I've ever seen them, at the 14 weeks. All right, so, and it's possible to expedite through the Department of State if you have a good reason. Last year, I know that if you could show that your physician had signed a contract to start July 1st, they would be willing to expedite in many cases. The Department of State then approves and sends it to the USCIS for final approval, and that takes 2 to 6 weeks. Now, the bonus point there is that you can file the H1B petition as soon as the Department of State approves the waiver without waiting for USCIS. We don't like to, but we can do it and then organize the USCIS to talk internally with each other to make sure the waiver and the H1 are approved all at once. Okay, so that's sort of the timing. If you look at the longest time, 6 months, 14 weeks plus 6 weeks, that pretty much gets you to 9 months. It probably won't take that long, but we just do it as a cautionary note. Okay, now we're going to just go into some of the common requirements of the federal waivers versus the state waivers. Okay, so federal IGA waivers, only for J1 waivers. Obviously, your H physicians to H physicians don't have these restrictions. They all have to have an employment contract for 40 hours per week of direct patient care for 3 years. And make sure that your contract talks about direct patient care. That is sort of a rule that the State Department of State added on a couple of years ago, and they will ask for you to amend the contract if it doesn't say that, because you will note that many states only require 32 hours per week, for example, of direct patient care. All federal waivers, this can be a deal killer in many instances, is that non-compete clauses are prohibited. I'm sure everybody knows, but just as a reminder, it says if you don't work for if the physician terminates employment with the employer, they're not allowed to practice medicine within a certain geographical area for a certain period of time. And many states are coming to prohibit them as well. But federal, no-brainer, no non-compete. All federal waivers except HHS permit primary care and subspecialties. One anomaly you will run into is that ARC and some state 30 programs require liquidated damage contracts. And what those say is that if you leave the employer, you owe the employer $250,000. So that's off-putting to the doctors. It's rarely enforced. I think collectively the attorneys may know of literally four cases during the last 35 years. So it's not enforced, but it sends a message to the doctors that if anything goes wrong in the relationship, the doctor is presumed guilty. Next slide. Next. Okay, state 30 programs. Okay, again, 30 hours full-time, 40 hours direct patient care. Agree to commence employment within 90 days of USCIS approval of the waiver in H1B status. That often isn't possible. It's rarely enforced, and doctors do worry about that 90 days, but it really is to avoid somebody's uncle sponsoring them for a waiver to start in 2 years. Okay, for the state 30, facility can be located in a HIPSA area, an MUA area, or a flex slot. Again, we said that the flex slots are a tool for you to recruit physicians in areas which are not medically underserved. Okay, so if you have a choice of which waivers to use, for example, Kentucky has 4 waiver programs. Some states are lucky that way. They have ARC, DRA, HHS, and the Kentucky State 30. So they enjoy a bounty of options. Just to give you an idea, states which rarely, if ever, use up their waiver are DC, Nebraska, what other states? Hawaii never uses its waivers. More and more states are, but there's still probably 10 or 12 states that don't use them immediately or use them later. For example, California functionally only takes primary care physicians. However, on July 1st of every year, if they have leftover numbers, they will open them to subspecialists. And this year they actually had 10 leftover waivers. The problem there, of course, is that physicians often can't wait till July 1st to see what their future is going to be. That would be July 1st after they finish their commitments on June 30th. The other caveat for recruiters is to make sure your doctors extend their J1 status to take a board exam if possible. And that will give extra time to take care of issues, unexpected issues along the way. So if their board is in October of 2022, they can get an extension until October 31st, 2022. Nobody's very happy about it, but it keeps the doctor in legal status and able to change status. So if you have a choice, next slide, please. Okay, is a state 30 in the state user-friendly to J1 physicians? Based on years and years of experience, this is what we have for you. States that have burdensome paperwork and or filing fee requirements: Alabama, New Jersey, Ohio, Pennsylvania, New Mexico. Texas basically doesn't have burdensome paperwork, but just a caveat: in Texas, it's no longer sufficient to have your job location be in a medically underserved area. The state of Department of Health in Texas takes that list and then pares it down to the areas they feel most needy of people. So don't get stuck in that trap. And if you have a Texas job, be sure to email the Texas Department of Health and ask them. And they generally use up all their waiver slots by early September, although they may have some left over. States are user-friendly states: Oklahoma, Nevada, Oregon, North Carolina, South Carolina, Maine. Actually, Maine now uses up all their slots. So I would put that: Delaware, DC, Kansas, Louisiana, and Nebraska. One thing I would say about South Carolina, which is a real boon for people looking to place doctors there or employers looking to hire doctors there, both South Carolina and Delaware have an excellent system. They have what's known as a slot reservation system, so that if an employer knows they're going to need, for example, a neurologist, in advance of knowing who the candidate will be, they apply to the state to be accredited as a slot, and the state will then give, practice X in Columbia, South Carolina, a slot for a neurologist. And that takes pressure off of everybody. It's really a program I would advise the states to adopt because it inserts certainty, and the doctors do want certainty, as do the employers. So if I know now I'm going to need a neurologist and I'm in South Carolina will quickly tell me I can have a slot. And that helps me recruit the doctor, because I can say, look, you're guaranteed a slot there if you need a license and so forth. So that's a real boon to recruitment in those two states. And we've asked other states to try and work toward that kind of system because of the certainty of availability. Okay, and you want to be careful not to believe everything on the website. State 30 programs, some of them are not updated. So you want, the state people are usually very helpful, very friendly, very prompt, and tell you what the situation is. For most state 30 websites will leave you believing that if you have a subspecialist you're trying to recruit, you will have very little chance. In fact, you can disregard that in many, many states, because the reality is that most of their applications are coming for subspecialists and the demand for primary care is down. And those states which require applicants to use the federal program, if they're eligible, free up the state 30 slots for subspecialists. So many, many physicians still believe that their chances of getting a waiver are far less if they're a subspecialist. And while it looks like it on paper, it doesn't seem to be the case, and particularly with the expansion of HHS programs for primary care, many states requiring you to use the federal program if you can. I think that the shortfall for subspecialists will be much less. Next slide. The advantage of the state programs over federal, if you have a choice. So many employers want non-compete clauses. Federal and interested government agencies prohibit using non-compete clauses. And sometimes I found that can be a deal killer. Then sometimes physicians do not want liquidated damages clause. Separate and apart from those few waiver programs that require a liquidated damages clause, many employers want them too, because say, well, what if I invest 25, 30,000 and they leave me at 3 years in 1 day? Some states permit them. In fact, I would say probably most, if they're done properly. You want to be careful how they're drafted. And then state programs are more flexible in their job locations. Most will permit HIPSA, MUA, MUP, and flex slots. Okay, now we want to get to, you find an H1B doctor and who is exempt from the cap. I know this is complicated. Just call us if you have questions. Okay, exempt from the cap, all J1 physicians with interested government agency. Once the physician gets the waiver, they own that waiver and they can put it in their pocket. So if they complete their 3 years and transfer to another employer, that waiver goes with them. So if you're a for-profit employer and you're not in an underserved area, those J1 physicians are available to you after they complete their 3 years. So it always remains with them, even 20, because of the quotas for some countries, particularly people born in India and China, literally you have physicians who will be transferring over the years and take that J1 waiver and carry it in their pocket for years and years. Next one causes lots of confusion and conflict. Oh, not next slide. Oh, can you go back? Thank you. Okay, quickly, the beneficiaries of H1 petitions filed by institutions of higher education. Okay, we don't know what that is. Or, this is the important one, your takeaway here, affiliated nonprofit entity. Those are residency programs. The next one is your most important takeaway, nonprofits affiliated with an institution of higher education, including teaching hospitals, many community health centers, and health clinics. So today, most hospitals are still nonprofit, and more and more hospitals and community, including community hospitals, have affiliation agreements with a university to teach their students. Okay, so Recruiting Plus is the next one, really applies to hospitalists who did their training in H status. If you're employed by a for-profit entity to work at an institution of higher education or the related nonprofit entity, that's a Recruiting Plus. That's called By-at exemption, employed by a for-profit to work at a nonprofit affiliated with the university. Okay, if you've been counted one against the cap once within the preceding 6 years, you don't get counted again. Beneficiaries of multiple positions. That means if you have one nonprofit and one for-profit, they can exist side by side. The for-profit may piggyback off the nonprofit. Okay, the thing to also remember, and the doctors often forget, is that if you undertook your residency training on an H1B visa, you lose your cap exemption if you're transferring to an employer who is not cap exempt. So everybody has to keep that in mind. There are a number of workarounds for that, not a problem. Next slide. Okay, green cards. There we have the pot of gold at the end of the rainbow. They might not mention it to you. It's amazing what people won't mention at their interview because they're afraid that the employer will be afraid to sponsor them and say, forget it. Tell the recruiter, I don't want any J1 positions. We'll talk about overcoming that, and hopefully your questions will help us focus that. Okay, virtually all physicians want a green card. Yeah, you can probably put all there. They usually have to obtain it through employer sponsorship or a physician national interest petition. One of the recruiting bonuses that you will have is employers who offer to commence a green card before employment starts is a great recruiting tool. There's one hospitalist company that does it called Apogee, and they will start the green card as soon as the contract is signed, not even work. So it builds physician commitment, loyal to the employer, and they think you care about their green card. A very frequent complaint I hear is the employer doesn't care about my green card. They'll call, started their waiver, have some issue with the situation. Now say, well, what about the green card? Well, we haven't discussed it. We recommend that the timing of the green card and the commitment to do it and the conditions should all be set forth in the initial employment contract. Okay, for India and China-born physician, it may be essential to start the green card at the earliest possible moment in order to get them to work at all under the 6-year limit in H1B. Okay, so if the physician is married to an American citizen or a permanent resident, that's a bigger bonus to the employer. No employment sponsorship for the green card is required. Okay, if we're out of waiver options, there are other non-immigrant visas that can be had. J2 spouse, O1, and sometimes F1 student, which of course does an employer no good. Okay, what is prohibited with the 2-year home residency requirement is you cannot have an HL or immigrant visa without a waiver unless a Canadian citizen. Next. Hiring game plan. Okay. Possible snags we've discussed. Non-compete clauses. Employer must say, no way, no how, I want a non-compete clause. Somebody, some doctor, I had this very recently. We had experience with a doctor and we want a non-compete clause because we had a doctor who went out next door and competed with us. Well, upon examination, it turned out that happened 15 years ago. We went into it and they were finally able to agree to not include the non-compete clause. Work locations, you want to be careful about that. Remember that the commitment is to work at least 40 hours per week in the designated and authorized area. Do not send the person elsewhere within the 40 hours. After the 40 hours, they may work elsewhere. All those locations should be possible locations, fill-in locations for somebody who's sick or on vacation. They need to be listed and be careful about that. Okay, waiver applications deadlines vary a lot. Some have first come, first serve, primary care first. Some have an application period where all applications received within that period are considered equally. And And then they have different application periods depending on whether you're primary care or a subspecialist. And so when you see all that, you want to talk to your physician immigration lawyer, which hopefully is us, to find out how you're going to deal with the application periods. All right, some of the recruiting suggestions. Next slide. Boy, Amber really gets the slides up here. We recognize the coach there even. Okay, initial steps. So we've got employer, recruiter, immigration obstacle, and immigration lawyer to solve. Now, it should be remembered that the immigration attorney virtually always represents both the employer and your physician. And it's important for them to know that. I hear way too often that, oh, that's my employer's lawyer. Well, legally, the lawyer represents both of you, and it's important to have the physician feel included in the process. Some of the things you should do is very early team up with an accessible expert physician immigration lawyer and make them a part of your team. Complete the early immigration checkup to avoid any snags and disappointment later on. Interview the physician as early as possible, make them feel welcome in the community. File the waiver application at the earliest possible moment, consistent with sound hiring practices. I mean, I wouldn't say bring a doctor in on a Friday night. We call it the Friday night fly-in, have them leave on Saturday, sign the contract before they leave. Both sides want to do their due diligence to see if it looks like a good fit. So for example, the physicians are pretty much in panic mode, right? Everybody knows somebody who didn't get a waiver because they were late. The fact of the matter is, if you have the federal option, you're not in any hurry, because particularly if you're an HHS waiver, because they do them so quickly. All right, for a little footage replay here from the booth. Okay, build a relationship with your doctor. Make sure there's a good fit. You want to know about their family, the schooling, spouse's needs. Ensure the site visit is for a few days and they meet all the people we discussed earlier. Your real estate agent, your banker, your mayor, the medical community, make sure they get a tour of the hospital. If it's not a hospital-based practice, sometimes that step is skipped. And then the doctor says, I didn't know this was happening at the hospital. Develop a community integration plan. Be a welcome mat. Introduce the doctors to, as we said, important community members. Have them meet somebody from the school district. Take them to a local eatery. Remember, the physician is as anxious about a new job and community as the employer is, so everything you can do to make them welcome is a good sign. Next slide. Much like football, players learn from watching playbacks. We benefit from analyzing case studies. So we're going to have a few little samples here. I'll go through them quickly again. You can listen to this by podcast. You can see the slides again, or you can see it on YouTube. All right, next slide. All right, here's some samples that may sound familiar to many of you. The national interest waiver. Okay. You call ACE and tell the lawyer and tell her that your best client has to have a neurosurgeon in a medically underserved area of Connecticut no later than July 1st, 2022, the date after Dr. Brain finishes fellowship training. ACE tells you, the employer, and Dr. Brain not to worry, as ACE can file a physician national interest petition and green card application, and we'll have them to work by July 15th. So they missed out on the Connecticut waiver cycle and are hypothetical, and they can file a waiver, J1 waiver, the next year for Dr. Gray. So he can usually work indefinitely on the national interest waiver. And do not try this workaround without expert advice from an immigration attorney. Next hypo for you. Okay, Joy, a recruiter for a for-profit hospital staffing company, has just learned she needs to hire 3 H1B physicians and 2 J1 physicians and needs all of them to work by July 1st, 2022. Jay calls Ace at home at 10 p.m. that night in a panic and tells her she needs 5 doctors by July 1st. Can she do it? Ace tells Joy to simply hit the hay, go to sleep, as the problem is not a problem at all. The physicians are recruited to work at a nonprofit hospital with affiliation agreements with 3 universities, and HHS waivers are available to her J1 doctors and to her H1B physicians as well. So Joy can go to sleep here. Please type in all your questions for us. We have a couple more slides and then we'll get to your questions. The H4 spouse. Some of you have heard terrible things about the H4 spouse work permit, all of which are true, but are not true anymore. The last presidential administration had it high on their hit list to absolutely and forever abolish H4 work permits. That was litigated, and no, they weren't allowed to eliminate them, so they are back for now. Okay, so in our sample, the value of the H4 spouse with the work permit. One of your favorite clients wants you to find the best cardiologist in the world to work in her small town. They need one immediately as their last 2 died last week in a boating accident. This actually really happened, by the way. You search for a week and find one who will complete cardiology on June 30th, 2022, who is on an H1B and married to a physician also in H1B status. There are no colleges within 500 miles. The hospital is a small rural hospital with no university affiliations, and the doctor will exhaust his 6-year limit in H1B status on June 30th, 2022. ACE tells you not to worry, as your cardiologist married up by marrying an H1B with an approved I-140 petition. This means ACE can obtain a change of status to H4 and a work permit by about August 28th, and not to worry about exhausting her 6 years in H1B status, as she will shed the H1B garb for an H4, which is not counted against the cap. So please ask me any questions you have about my hypotheticals, which were actually real world situations and solve problems. All right, that ends our direct presentation. Now we'll take questions. Please type them in the chat box. First question is premium processing available for an I-140 form? That is a great question. If premium processing is available for I-140s, depending on the type of I-140. If it's an I-140 supported by a PERM waiver certification sponsored by the employer, it is generally eligible for premium processing. If you're doing employment-based second preference category I-140 under the exceptional ability or the physician national interest petition, it is not. Those are now taking about 10 months if they're physician national interest petitions. So you want to keep that in mind in the timing. And EB1, if you have a rocket scientist doctor, EB1 extraordinary ability self-petition can be filed premium processing. Next question. Is it necessary to sponsor a position for a green card in order to do a J1 waiver? The answer to that is absolutely not, but if you wish to retain the physician, give them visa security. As you all know, talk to doctors, more important than their salary is their visa security. So if they understand that you as the employer care about their visa status and their visa security, you're much more likely to retain them and build loyalty. Next question is, can an H4 visa holder file for a TPS EAD? Yes, they can. In most circumstances, they have to not have been out of status and things like that. Okay, next question, Amber.
I have one for you, Jan. So someone asked, you mentioned that in the instance that a transfer was allowed for extenuating reasons, would those reasons be reportable to NPDB?
Oh, that's a great question, Amber. That's the National Practitioner Data Bank. It depends on the circumstances. The physician will often, if the situation is such that they want out and the employer doesn't want to let them out, or they're being threatened with actions that are reportable, that gets to be a delicate situation. My experience is that most employers are goodwill, and most employers don't want an employee who's unhappy, just as you don't want an employee around who's unhappy. It can just, most employers are agreeable to a transfer. They're not happy about it. They're not happy about the money they've sent into it. So if it's reportable to the data bank, that gets more serious, because we all know that that's pretty much a career killer. And in transferring, employers, want to terminate with cause, without cause. That's in the professional non-visa world. That's usually the way it goes when things are not working out. Is for a termination without cause, or a resignation, even better. However, that bumps up against a conflicting rule in the immigration law of developing extenuating circumstances. So many waiver programs prohibit termination without cause. So that's going to be in the contract. And immigration doesn't like resignations at all. We try to minimize the situation and get everybody to agree that the termination is for unforeseen and unanticipated circumstances due to no fault of the physician. That is generally accepted by USCIS. But having said that, we do get RF requests for further evidence to give us more details about why it didn't work out. So the immigration rules are quite unfair to all on that point, because number one, whether or not a transfer is approved will only be determined by the USCIS decision on the transfer application by the new employer. So we always feel like we're walking on eggshells. We proposed to Congress, and there is legislation pending that would say that if the physician agrees to add on 1 year to their 3-year commitment to make it a total of 4, they may transfer, no muss, no fuss, not proving cause, not proving one thing or another. So, as I said, the majority of the time, the short letter works. But we have gotten RFPs. We got one just the other day. They want to know more about why the physician left. So, yeah, you want to worry about reports in the data bank, licensing boards. It's important for employers to, look at the first signs of problems and talk to the physician about it to avoid it worsening. Usually when we get a call from a physician, things are pretty far along. We've been put on a performance improvement plan, probation, and sometimes even fired. And of course, as it's important to remember that in the immigration context, we jointly represent the employer and the employee. So if there comes a point where they want to separate, we generally cannot represent either party based on potential or actual conflict of interest. Often the employer that they're leaving will execute a waiver of conflict of interest and be very helpful, because again, you don't want an unhappy employee around. Next question. Can an H4 holder start residency or work with a TPS EAD? Absolutely. Ellie made all these rules when she was at ECFMG. Basically, it was on the ECFMG website. You're permitted to begin your residency training in any visa status, period. However, we have heard reports of programs that don't like sort of EAD types of work permit because they're only issued for a year. Good news and congratulations to the people currently running USCIS. They've now extended many of those work permits to 2 years. So there's no reason you can't. I think there's pushback from a lot of programs because they don't want to have to worry about whether or not your EAD is going to get extended. And right now, the bad news is that EAD extensions are taking a very long time, 6 to 7 months, although in many, if not most of them, you can work for 180 to 240 days while it's pending. It's just that it's a hassle for the administration to keep up with those kind of work permits, but they definitely, in my opinion, should not have a problem with you doing that. Ellie, our guest, our star guest here, do you want to chime in on that? I don't, Ellie's still here? Okay. Next question. There's other ways to retain physicians. As for all employees, treat your employees nice, let them know they're appreciated, integrate them into the community, invite them around. And I have actually my top 10 tips that when I presented to doctors for finding and keeping your waiver job, from the interview process onward. I'd love to hear from some of you on the call, what tips you have, but basically integrate into the community, pay your respects to all the doctors in the community. Upon arrival, there may be some old timers who are suspicious of a new, young, hotshot doctor, trained in a big city with up-to-date knowledge. We call that avoiding the smart young doctor syndrome. It happens, and just from our clientele a couple times a year when the medical community decides that they want the doctor out of there. And very bad things happen when that happens. It's unfortunate. But we try to counsel the doctors to do everything on their end to integrate. Don't segregate, introduce yourself to the medical community, give seminars for nurses and other professionals, and buy a house. That will make sure that they do that. Next question, Amber.
I think that's all I have.
Okay, I see that we're out of time. I want to thank you all for attending. Please email me any questions you have. And again, we'd be happy to help you with all your physician immigration needs.